Hi, my name is Mical Samuelson Duvall, and I'm a doctor in the Houston, Texas area that takes care of Department of Labor patients. And I've made this instructional video to help Department of Labor patients get through the chaos that exists once you have an injury on the job. So I'm going to start out with the USPS Injury Compensation Handbook that is free online. If you type in EL-505 USPS, there is a PDF version of it that's always available online. But it's very informative, and it shows you as a patient or employee what your obligations are, as well as the HR department, your supervisors, as well as your physicians, what their obligations are to you in moving forward with your claim and learning about the Department of Labor process. So I'd like to start out by talking to you about the purpose of this handbook. The handbook's purpose is to explain the history of the USPS compensation program and the provisions of the Federal Employees Compensation Act, or FECA. It also gives certain provisions for staffing and supplying the program, as well as responses to employee injuries, claims management, records management, limited duty and rehabilitation, as well as legal issues surrounding injury compensation. Using this handbook alone is not sufficient for effective management of, obviously, the injury compensation program. But it is important to note that the boxes that exist in the handbook, the obligatory responsibilities of the USPS, these obligations that were set forth and boxed, are mandatory for the USPS. So to begin with the history, the injury compensation program was established in 1978, and it's important to understand this history as well as the compensation program. In 1908, Theodore Roosevelt signed legislation to provide workers' compensation for certain federal employees in usually hazardous jobs, and the scope of this was very low and restricted. But then in 1916, the compensation law for civilian federal employees was enacted, which originally included wage loss compensation, medical care, and survivors' benefits provisions for people who were deceased on the job. In 1974, FECA was amended, increasing benefits and specifically changing the law by adding provisions such as continuation of pay and claimant's choice of a physician. The effect of this amendment eventually led to the establishment of the USPS Injury Compensation Program. So what is the purpose of all of this and the handbook? Well, the handbook and FECA provides compensation benefits to civilian employees of the United States for disability because of personal injury or disease sustained in the performance of duty. FECA also provides for the payment of benefits to dependents if a work-related injury or disease caused an employee's death, and it's intended to be remedial in nature, and proceedings under it are non-adversarial. Employee entitlements. One is the continuation of regular pay. So an employee's regular pay must be continued for up to 45 calendar days of wage loss because of disability and medical treatment following a traumatic injury. This is to ensure that the employee's income is not interrupted while the claim is being adjudicated. This is very important that all of your forms get in to a physician if you're starting a CA1 or even a CA2 before that 45 days. And you can also go to chapters 4 and 13 for claims management, as well as timekeeping and accounting. Also, in cases of total disability, an employee is entitled to a compensation at the rate of 66 and 0.66% of the employee's established pay if there are no dependents, and 75% of the pay if there are more dependents. So as physicians, we look at compensable claims under FECA, and if a claim is accepted as compensable under FECA, the injured employee is entitled to medical services, and that's where I come in. In the beginning process of filling out your CA1s, as well as treatments and rehabilitation, hospitalization, medications, and then also referrals to surgeons if the injury calls for surgical management. Employee entitlements include examinations, treatment, related services such as hospitalizations, medications, supplies, transportation for their claim. However, preventative medication is not authorized under FECA. So everything having to do with your compensable claim is, but we'll say high blood pressure, diabetes, are not covered under FECA. It is good to know that once you have this acceptable compensable injury, as long as you continue to be compliant, that you will continue to have this care throughout your life for this injury. And there is no maximum or time limitation on your medical care through this federal plan. You also have appeal rights. If an employee or a survivors disagree with a final determination made by OWCP, a hearing may be requested. There also is a provision for additional review by the OWCP and right to appeal to the Employees Compensation Appeals Board, a separate entity of Department of Labor. And there is also one other avenue of appeal, and the USPS is not entitled to appeal. Only the type of appeal may be requested by an employee at a time. Only one type can be requested, and the types of those appeals include a hearing, reconsideration, and going before the Employee Compensation Appeals Board. There are also penalties. So the one very important reason to read the handbook is to stay compliant within the handbook, because there are penalties if you are not compliant. There's a penalty for a false statement. If any employee, supervisor, or representative who knowingly makes a false statement with respect to the claim under FECA may be subject to a fine of not more than $10,000 or 5 years in prison, or both. That's a pretty steep fine. There's also a penalty for a false claim. If any employee, supervisor, or representative who, with respect to a claim under FECA, enters into any agreement to obtain the payment or allowance of any false or fraudulent claim may be subject to a fine of more than $10,000 or 10 years in prison. Also, there's a penalty for refusal to process a claim. So if you have a supervisor who isn't processing your claims, if you have a supervisor who hasn't submitted your CA1, your CA2, your CA17s, or they won't give you a CA17, there's a penalty of refusal to process your claim. And that is any employee or supervisor responsible for making reports in connection with an injury who willfully fails, neglects, or refuses to do so, induces, compels, or directs an injured employee or to forego filing a claim, or willingly retains any notice, report, or paper required in connection with the injury may be subject to a $500 or 1 year in prison fine, or both. There's one other penalty, which is penalty for fraudulently claiming or obtaining benefits. And claimants convicted of fraudulently claiming or obtaining benefits effective 9/30/1994 lose entitlement to their medical benefits. This is one way that you can definitely lose your FECA medical benefits. And then pending disciplinary action. The USPS administrative disciplinary action must not be delayed based on current claim status. So relevant provisions under FMLA is also something that's very important to look at, and this is where the handbook kind of disguises one of its sentences. And you all probably have heard about it before from your supervisors, but this is where in Chapter 1 they talk about FMLA as well as Department of Labor proceedings. So basically, an employee may be on workers' compensation absence because of a job-related injury or illness that also qualifies as a serious health condition under FMLA. The workers' compensation absence and FMLA leave may run concurrently, but that's subject to proper notice and designation by the employer. So basically, you have Department of Labor and your reason for your compensable claim under Department of Labor that does not have to be added to FMLA. And then you have what's mandatory for the federal government for all employees under FMLA, which gives you the 12 weeks a year that will hold your job for you for those 12 weeks. So at some point, the healthcare provider providing medical care, such as myself, pursuant to the workers' compensation injury, may certify the employee is able to return to work in a limited position. At that point in time, we fill out a CA-20 or a CA-17 if possible. And if the employer offers a position based on that limited duty description on the CA-17 provided by your physician, and the employee does not accept the position, the employee may no longer qualify for workers' compensation benefits. But if the employee is entitled to continue unpaid FMLA, so if you're still within that 12 weeks off of leave, either until the employee is able to return to the same or equivalent job, the employee will continue to have their FMLA benefits until the 12-week FMLA leave entitlement is exhausted. So you can lose your Department of Labor rights and benefits if you don't accept a position, as long as under this relevant provision under FMLA. I just wanted to go over all of this with you, Department of Labor patients or employees. This is a hard position to be in when you have a new injury. You don't know where to go. You don't know where to get this information. But this information is out there and accessible to you 24/7. And that's why we're making this informational video to help you find your way through the mire that exists within the USPS or TSA system. This is just for the USPS handbook.